And where did I put it? I had it up a second ago. Pull it up. There we go. It's 23/12/29. We're being live streamed today, so please keep that in mind. Each side will be given 20 minutes. For the appellant, we typically reserve 5 minutes, but we can change that if you would like. Mr.
That's
Rosenthal,
fine.
is that how much time you'd like? 5 minutes?
Yes, thank you, Your Honor.
Okay. Well, I'm sorry, I should have introduced myself. I'm Judge Nardella, and joining me today is Judge Wozniak and Judge Smith. And counsel for the appellant whenever you're ready.
Okay. May it please the court, Stephen Rosenthal on behalf of the appellants Coddington Road and Durbin Road. It's nice to be here in the 6th DCA for the first time. This appeal involves a single legal issue, one element of one claim, duty in a negligence claim. But it's an important issue because the decision about whether the defendant owes a legal duty to the plaintiff controls whether, as the Supreme Court has said, the courthouse doors are open to the claim. The trial court in this case closed the door in our face early in the case using a legally flawed analysis.
The defendant here is a special inspector, correct?
That is right.
Does special inspector exist outside of 553.79?
I don't believe it does.
So it's really a creature of statute then, correct?
The nature of the role vis-a-vis the government, correct, and vis-a-vis the contractor, that's right.
So I'm struggling with, so this is under the Florida Building Code, and the 553.72, which describes the intent of the legislature in enacting the building code, it talks about having a uniform code throughout the state to be able to enforce uniformly, and it's for the public safety, health, general welfare of all the people of the state of Florida, not really anyone in particular. And where I'm going with this is the Trianon case from the Florida Supreme Court, which was decided before I believe the special inspector provision was enacted. But there's language in there that's troubling me. The government clearly has no responsibility to protect personal property interests. We find no indication that Chapter 553 was intended as a means to guarantee the quality of buildings for individual property owners. How do we get around that language and the legislative intent here?
No problem. And Judge Wozniak, I just want to let you know, I don't know if it's my audio, but you're coming through a little garbled. I can hear you, but just so you know, that's
okay.
fine.
Thank you.
Yeah, me too. It's a little copy, Judge Wozniak. We can hear you.
Okay, do I need to repeat anything or
No, now it's very
okay.
clear.
Okay, good.
So
I'll get a little bit closer. I think that's the issue.
Let me see if I can address your concerns. I think the points you're making would be really on point for a claim predicated on a statutory argument, a statutory basis for the duty. And I think where you're going is to say, well, if that's a creature of statute, how can you have something outside of that? How can you have a common law predicated duty? And my answer to that question is that there really is, by virtue of the facts of what the defendant does, irrespective of the status that is clothed in by the statute, that gives rise to a duty, a common law duty, separate and apart from the statutory duty. And
are there other instances where and I don't mean to interrupt you, but just following up with exactly what you're saying right now, are there other instances where there's this statute, something created by statute, a role created by statute, where there is a common law duty that the courts have found that?
That's an excellent question. I'll have to think about that. I'm getting a little feedback. Nothing occurs to me immediately, but I think that let me also address the point about Trianon, the case you brought up. That case, I think, is quite easily distinguishable because what it was talking about was the government inspectors saying that they do not owe an obligation to in that case, the apartment dwellers in the Hialeah building that sued. And we're not talking about enforcing a common law cause of action against a government inspector. We're not, in this case, talking at this point on appeal about enforcing a statutory cause of action against a government inspector. We're talking about a person who is a professional engineer, an engineering firm that holds itself out to perform engineering services. To get to your question, I think the key is this. The Florida Supreme Court has made it extremely clear that the sole test for determining whether a duty arises well, it can arise from four different kind of fields that they've identified, but one of them, and the one that we're basing this claim upon, is the facts of the case. What did the defendant do? And I think the fact that the defendant happens to be a statutorily empowered actor doesn't take away from what it actually did. We're not
Counsel,
saying.
Can I follow up with you right there? Can we pause on the defendant's conduct? 'Cause I think that's an interesting point. My question is, based upon your argument, who can you tell me is outside the class of persons to whom this defendant, based upon their conduct, did not owe a duty of care?
So you're asking me to tell you the negative side of it, right?
That's
I
right.
mean, I think that there could be a range of people who are outside that duty, the zone of the duty. Obviously, someone who has no contact with the property, no ownership interest in the property is clearly outside of that duty. I mean, that's sort of so obvious, right? It's not helpful to say that. I think what's an interesting point that you may be getting at is, what is it in the law that restricts the unbounded scope of that duty? And my answer to you would be, if that's the gist of your question, it's not so much the duty inquiry, it's the other aspects of the tort claim: breach, proximate causation, and damages. Probably mostly in proximate causation. That's what the Florida Supreme Court in McCain recognized, and subsequent courts have emphasized. So I would say that there's a fairly broad scope of the duty to anyone who comes into contact with this property or owns this property.
Having undertaken this assignment, what could the defendant have done differently, if anything, to narrow the zone of risk here to not include your client?
Well, aside from not, as we allege, negligently performing the task, I don't think it could do anything vis-a-vis a party with whom it's not in privity. With parties that it's in privity, it can obviously contract out of that. But we're in tort here. And so I think that the focus has to be on this single prong. And that's, in a way, it's somewhat artificial, I recognize, because Judge Nardelli, your questions are broader about liability, but the liability picture is formed by adding up four different elements. And we're only on element one. Liability is getting around home base, and we're on trying to get to first base. And what the Florida Supreme Court has emphasized time and time again is that courts need to let the runner get to first base, if you will, if there is a duty, because duty is the essence to playing the game. And here we have been told there is no duty, and that's legally erroneous under the governing standard. So I would urge the court not to look at what's on second and third and home plate, because we're really only talking about first base and that duty element. And, I believe that the proper result in this case would be a reversal and remand, finding a duty under the well-established law, and then it will remain to be seen whether the runner can get to second base or whether proximate causation can be proven.
Counsel,
What is
if
the
I could-
language?
Sorry, go ahead.
What is the language shall be responsible to the enforcement agency that's contained in subsection 5B of the statute? What does that language mean to you?
I'm looking for this precise line that you're talking about, Your Honor, 5B.
It's the one that says that the fee owner shall select and pay all the costs of employing the special inspector, but the special inspector shall be responsible to the enforcement agency.
But I think it means that the inspector basically has to respond to the enforcement agency. If the local agency says, we need the following information from you, or you haven't done anything right, they are obligated to respond. I don't think that it means preemptively, if that's what you're implying, that you are solely legally responsible to this governing agency. I mean, surely they would also be legally responsible to the party that hired them. I mean, in the most basic sense. So I don't think you can read that language to preclude a claim like this one, if that's perhaps what you're implying. So,
It does seem vague to me. The responsible to, it just seems vague, but under your interpretation, it almost makes it seem like that's superfluous, because they should be responsible to the entity that hired them too. So why include that specific language?
So I'm gonna have to scan the statute more closely to answer your precise question. I would say, obviously, no party has raised this issue before, so I'm hearing it for the first time. And to the extent that Judge Wozniak, that's a kind of dispositive question for you, I very much appreciate the opportunity to file something to answer that, because I, on the fly, don't have an answer for you. I also don't know of any case law that has addressed that specific statutory construction question. And if I can try to just refocus the argument to the point, I mean, I know Judge Smith had a
Before
question.
you refocus, if I could ask you a question, somewhat going along with the other questions that have been asked. So in reading your response to defendant's motion for summary judgment on the very first page, under the heading introduction, you state, for over 50 years, Florida courts have held engineers liable to those foreseeably injured by their negligence. Can you cite to me any Florida case in the last 50 years where an engineer who performed services during construction was held liable to a subsequent purchaser for damages?
I believe that we have cited several in our brief.
Go ahead and, yeah, tell me, because I've read through the briefs. I didn't see anything in that regard, but if you've got some, please let me know.
Let me see if I can find it. I feel that you all have recognized the fact that we have some summer law clerks who are watching this argument, and they're probably relishing the fact that I don't have answers to a lot of the court's questions. So I'm embarrassed. I will have to point, Your Honor, to those when I have a moment, the best cases that I think we've listed, which have been cases in which folks involved in the construction of a building, and I'll have to be sure if it's engineers, have been held responsible to someone who is not the immediate contracting party.
So I will tell you, I'm not aware of any. That's why it was a bit of a loaded question, honestly. But I'm not aware of any. But I was curious if you had any cases in the last 50 years that you're aware of. As you consider that one, I also note on page 6 of your reply brief, you cite to the Casa Clara decision in your footnote, stating that the Simmons case is still good law, and that you state that the Florida Supreme Court receded from Casa Clara, and I think Casa Clara is something we really need to talk about, because you also discussed the economic loss rule, and my question is, if a building is a product, doesn't this entire claim fizzle under the economic loss rule?
Well, I mean, in the Tiara condo case in 2013, the Florida Supreme Court receded from the economic loss rule. And so
Contractual, they did the contractual economic loss rule, but they didn't the product liability. And in the product liability economic loss rule, they specifically cited Casa Clara. And if you look at the Casa Clara decision, they define a house as a product. And what they said in Casa Clara was that you've got these concrete suppliers during that the homeowners tried to directly sue. And the court said, no, you can't do that because a building's a product. And therefore, we're going to protect those that were involved in the manufacture of the product. You can sue, I guess, the person that you're buying the product from, but you can't go after the individual component contributors to the product itself. So my question to you is, how does this case stand under the economic loss rule?
well, we're talking about a service provider here. An engineer is a service provider, not a product manufacturer, a component manufacturer. And services stand completely differently than product cases. So I don't think.
Okay, well, let me take that. I understand your position on that, but so let's just say you've got a laborer that works on a building, and they're given the nails, and all they do is bring their services. They come in and they hammer the nails, and they're building the building. You're saying that that the Casa Clara decision, which says that the economic loss rule treats a building as a product, that those laborers, because what they did was swing a hammer and hit a nail in, but they didn't actually supply any particular product, we should be able to sue them, but we can't sue the guy that brought the concrete, and we can't sue the lumber person. Or better yet, if those guys that were hammering the nails, if they would have paid for those nails, then we couldn't sue them. But because they didn't pay for the nails, now we can sue them. Would that be your position?
I think the distinction, the line being drawn is a service provider versus a product manufacturer or supplier. So the guys hammering the nails into the roof or the 2x4s of the building are not situated in the same way vis-a-vis the economic loss rule as the person who supplied the tiles for the roof, for example.
Okay. Do you have any cases, Florida cases that would say, stand for what you just said, that a service provider should be treated differently than someone who actually physically provides materials to the building?
Well, I think that the Tiara Condo case says that, but Your Honor, I have not looked at that specific issue. I confess. The focus of this case, as I see I'm getting down to 5.5 minutes, has been on simply whether the McCain rule has been applied properly. Our view is it's clear the McCain rule was not applied properly. It's clear that the Florida Supreme Court has time and again said McCain is the starting point for establishing a duty under Florida law. That's the sole issue in this case. The only reason the economic loss rule we brought up and is at issue is that 3 of the cases that Mr. Brown's client has brought up, which are 2 of which come before McCain, involved implications of the economic loss rule. One of them was a 3rd DCA case that was after McCain, but also was governed largely by the economic loss rule concerns about limiting tort liability, which have been completely changed by the Tiara Condo decision in 2013. And so the court has given me a number of things to chew on, which I'll try to do during Mr. Brown's presentation, but otherwise I'd like to reserve the remainder of my time for rebuttal.
Mr. Brown, whenever you're ready.
Thank you, and may it please the court. My name is Kurt Brown. I represent Arteman and Arteman's individual engineer, William Goodson. As the court's well aware, the creature of a special inspector is something that is purely statutory. It is created by the Florida Building Code Act, Chapter 553, Florida statutes. 553.79 is the specific subsection that details the general special inspection threshold plan and how this, again, the statutory creature conducts itself on a given project. And what that statute says is that if you have a threshold building, the enforcing agency here, Osceola County, is required to or must require the use of a special inspector. The statute goes forward and says the owner of the project has to pay for the special inspector, and then this is the provision that the court was referring to earlier. Under 5B, that statute specifically says that the special inspector is responsible to the enforcing agency. Now,
What does that language mean to you?
well, to me, that language means that again, that the special inspector's sole duty is owed to the enforcing agency. But then I would also add to that obviously there is a contract between a special inspector and the owner, and there would be a contractual obligation there as well. And I will get into this later if I have time, but one of the things that the Trianon case actually tells us is that a statute similar to 553, that entire chapter, so an enactment that is intended to benefit the general welfare of the citizens of Florida. The Trianon case says that a statute of that type does not automatically or does not independently create common law duties that didn't exist prior to that, unless that specific intent is stated in the legislation. And the only indication that we have of what the legislative intent was is 553.79.5B, which directs that the special inspector is responsible to the enforcing agency, or Osceola County, what we have here today. I would like to address the Trianon case, but first, the McCain decision. Obviously, the McCain decision is certainly applicable to our case. That sets out essentially Florida's restatement of when a common law obligation or duty might be owed. The McCain case applies to our case here today. However, factually, the McCain case it couldn't be more different.
But isn't it a matter of law? Do we get into the facts here? And kind of a follow-up question on that, looking at the trial court's order, it really focuses on the plaintiffs and how knowledgeable they were, experienced, sophisticated. There was the as-is clause in the contract, all those things. But the duty element under McCain, isn't it really supposed to be focusing on the defendant and the defendant's actions making the zone of risk larger at this stage, discussing duty, analyzing duty?
I would agree with that, Judge. The issue on that is that when we filed our motion for summary judgment, we were raising the grounds for that motion, and that the grounds for that motion addressed both foreseeability on both ends of the spectrum, according to the McCain case, in that the fact that this particular plaintiff signed an agreement that said that it had relied on nothing but its own consultants, and then decided to purchase the property as is, where is, with all faults. All of those things go to this proximate cause issue, which certainly it was raised. The grounds for it were raised below, and where we go with that is the fifth DCA decision back in Hahn Amcar, and then and also the McCain case. The McCain case, the Supreme Court actually recognizes the same thing the fifth did in Hahn versus Amcar, and acknowledged that although it's not common, there are situations where the court is absolutely, or it's absolutely appropriate for the court to take proximate cause away where the facts are unequivocal and there is no proximate cause as a matter of law. Those were those issues.
I appreciate that. I have two questions. One, the trial court's order, when it talks about McCain, it appears to me that it's trying to distinguish McCain by describing it as a bodily injury case. If you agree with that, would you concede that may have been error on the trial court's part to distinguish it on that ground, or no?
I don't know that I would. The way I read that order, Judge, is that initially the trial court judge states that there is no statutory duty, and then cites to 79(5)(b). And then it goes on, and the first sentence of that order states that there's no common law duty owed under the zone of risk analysis in McCain. And then the court goes on and discusses the other, I'd say maybe it's the sizzle on the steak that I added, as part of the motion to point out that, in this instance, these are the factual situations where they actually bought this as is, where is. So I think the court stated it applied the McCain analysis. Likewise, the trial court, the primary case that we rely on, obviously, is the Trianon case. We provided the court with the three other, and these are the only cases I could find in the state of Florida actually construing whether a special inspector owes a common law duty to a subsequent purchaser like Coddington. And in each one of those cases, they're all out of South Florida. Each one of those cases, the courts applied McCain, and Judge Lisa Small specifically stated that McCain requires that the defendant in that case actually create the risk. And what she recognized is that the special inspector in her case simply inspected the work and is not responsible for the underlying risk that was actually constructed by the contractor. That's exactly our situation here. Again, Arteman is the special inspector. Arteman did not create the underlying risk that we have. I hope I answered the court's question. Briefly on with regard to the Trianon case, some of the issues there that I wanted to bring out. First off, is the Coddington's attempt to distinguish that case. And they attempt to distinguish it because in that case, and as the court mentioned a while ago, the special inspection statute did not yet exist when the Trianon case was decided. But in that case, the plaintiffs, the subsequent owners of the condo, brought a claim directly against the enforcing agency, the city of Hialeah, who performed the statutory building code inspections. Plaintiff contended they were negligently performed, and as a result, these plaintiffs purchased defective condominiums. And what I want to point out to the court is that obviously, Ardaman's not a governmental entity, but that distinction is completely irrelevant. And we know that because another case that came out, a Supreme Court case came out a couple of years, 2-3 years after Trianon, and that's the Keisner decision. And the Keisner decision involved a plaintiff who again was trying to bring a negligence claim against a governmental entity. What was involved in that case was A, whether a duty was owed, and then B, whether that implicated sovereign immunity considerations. That is identical to the Trianon case. Again, private, third-party purchaser in Trianon is bringing a claim against the city of Hialeah saying their inspections were negligent and wants to hold them responsible for the defects. What the Keisner court did is they pointed their finger back at Trianon and explained what their approach was in that case. And what they explained is when you have a case that involves, you're trying to assert a duty against a common law duty against a public entity, and there may be sovereign immunity implications, it's essentially a two-part analysis. And they point their finger at Trianon and say, that is exactly what we were doing back in the Trianon case. We took the first step in Trianon and we looked at the facts of the case, and we determined as a matter of law that there was no duty owed by the government in performing those inspections. And because they came to that conclusion, they never got to the second step of whether or not sovereign immunity got involved. So ultimately, the fact that we had a governmental entity involved in Trianon really makes no difference at all, because the court never got to that part of the discussion because they found there was no overall obligation. And then obviously in the Trianon case, what that court does is obviously it actually analyzes Chapter 553 and instructs us as to what type of statute that was. The Supreme Court tells us that was a legislative enactment to protect the general welfare of the citizens of Florida. And essentially, in that type of a statute, they conclude that again, they point to the restatement, a couple sections of the restatement, but that no independent duties arise from that type of legislation unless the legislature specifically includes some intent to create that type of liability. The restatement sections that are discussed in Trianon, I think, are very instructive to this court. The first one is its restatement section 315. And what the Supreme Court said there is that there is not now, nor has there ever been, any common law duty for either a private person or a governmental entity to enforce the law for the benefit of an individual or specific group. How does that apply?
Do you know of any other, I think I asked this question of Mr. Rosenthal, but do you know of any other statutory creature that has been held to a common law duty?
I do not. And that is something I specifically looked for, and I was not able to find that.
Okay.
So again, back to the restatement, the other aspect of section 315 that the court raised is that there was likewise no common law duty to prevent the misconduct of others. So how does that apply here? there's no obligation on a private party such as Ardaman to enforce the Building Code Act, Chapter 553. And likewise, there is no common law duty on the part of an Ardaman to prevent the misconduct of a third party, or in our case, the contractor who actually constructed the project allegedly improperly.
Council, if I may, I want to give you a chance to speak to the same question that I had posed to opposing counsel. And that goes back to their reply brief. They cite the Simmons case. In the Simmons case, you've got a building contractor who builds a house is sold, however many times over. Somebody finds a building defect and then they sue because of the water intrusion that was caused by that building defect. A common situation we see in construction defect cases. Casa Clara overruled Simmons. So Simmons was no longer good law under Casa Clara. If Casa Clara is overruled by Tierra, then I suppose, does that revive Simmons and then expose you? Or is your position that Casa Clara is still good law? If Casa Clara is still good law, then why is a building not a product? And the economic loss rule, the dispositive issue here today?
Well, I believe that particularly in the context of professional services, which is what Ardaman does, they are an engineering firm. Casa Clara, I do believe is overruled, and in terms of and we really don't, as a lawyer that represents design professionals, we generally simply do not have the economic loss rule as an arrow in our quiver anymore. This resulted from Moransai years ago, and then up through the fairly recent Tierra decision. So,
was Moransai a decision involving the original construction?
Moransai was a decision where a engineering firm was hired to actually perform a building inspection, and it was a prospective purchaser of the home that hired that firm.
So not during construction.
Not during construction.
Okay. So I mean, I look at like the decision from the third DCA, the Epic Hotel decision from 2015, which is post Tierra, and they cite to Casa Clara, they cite to Tierra. They talk about a product. You can presume that there obviously was a hotel involved in this. You can presume the hotel owner lost the lawsuit because they're now the appellant and they're appealing. And whatever they lost got affirmed. And the citations that they give in the opinion are to the Casa Clara. They don't say you can't rely on Casa Clara in a construction setting. So I know you're saying that you feel that it's no longer available. I'm curious, other than the feelings, do you have any subsequent case law in which you would say, here's a Supreme Court case or a DCA case that said Casa Clara can't be relied on anymore?
I don't, Judge, and really my and again, as someone who defends design professionals, I think that really all that's left for us these days is perhaps the independent tort doctrine that still exists. But in light of the line of cases out there that, again, in the context of professional services, I don't believe, unfortunately, that the economic loss rule is available to us.
Thank you.
Moving on, again, that I don't believe I talked about the other restatement section, which was 288. And that's where the court points to the legislative enactments for the benefit of the general public that do not create an independent duty to individuals or specific groups. I only have a few minutes left, but what the Trianon case does with after discussing the two restatement sections is then they focus and burrow right into what our Florida Building Code Act is. And they state that there is nothing in Chapter 553 that evidences an intent to give an individual citizen a statutory right of recovery for the government's negligent inspection of the property. And then I think that the Trianon case makes a very good observation that I think is absolutely applicable to this case. And what they say is that in Trianon, if they would have found that the governmental entity, the enforcement agency in that case, had a independent common law duty to anyone that happens along and acquires that property, that they would essentially turn the governmental entity in Trianon into a guarantor or insurer against construction defects that they didn't create. And that's exactly what will happen here if this court finds a common law duty somehow springs forth out of Chapter 553 and makes special inspectors liable to, again, anyone that happens down the way and acquires the property. We would, in that case, be insurers or guarantors against defects. One of the other things I wanted to point out in my last few seconds is lastly, in Trianon, the court specifically states that they find no indication in Chapter 553 that it was intended as a means to guarantee the quality of buildings for any individual property owner or developer. So in that case, there is no basis for a Coddington to rely upon building code compliance as any sort of guarantee that there's no defects. Thank you.
What I'd like to try to do is respond to the court's questions to me that I was unable to answer during my initial argument, and then try to respond to some of Mr. Brown's points. First, with respect to Judge, I think it was Judge Wozniak's, our question about whether there's any other statutory creature held to a common law duty, which you asked both of us. It actually comes to mind that there are a lot of statutory creatures in Florida, statutes that regulate or even create entities. For example, corporations is the best example. Corporations are regarded as persons. They are purely creatures of statute, and of course, they have common law duties. Police officers are licensed and regulated by statute, but they can be sued for breach of common law duties. Lawyers are, although their duties are not necessarily prescribed by statute in the same way, they are creatures of statute and licensed by the state, and we, of course, can be sued for professional malpractice. Could go on and on. I think that the notion that just because someone is partially regulated or even entirely regulated by statute somehow takes them out of the realm of common law obligations is something that's novel, and I don't believe is supported by the law. On the
Council, if I may, I just wanted to jump in real quick and ask you to respond to the idea that so we've got Trianon out there that I mean, we as a court, we want clarity, right, in the law. So anytime, as soon as we make this decision, we want practitioners to be able to read the decision and say this is what the law is, and hopefully we don't create clarity, confusion, and then create clarity. So in essence, we want to take the law as it exists. I say all that to say, we've got this statute that says that the special inspector shall be responsible to the enforcement agency. We have Trianon, who says that the enforcement agency should not be held liable in situations just like this, where you have an inspector that doesn't do their job right. And then I'm going to add something else to it, which is you have 553.84, which creates a cause of action. The legislature has expressly said, if you've got a building code violation under 553.84, nobody's left without a remedy. You've got a 553.84 cause of action if you feel that there's a building code violation. Obviously, I'm not saying that you should have used that. I'm sure there's reasons why you didn't, but so the legislature's knows how to create a statute. They know how to create a cause of action. Why shouldn't we presume they knew how to create a cause of action? So why are you asking us as the court to create a new cause of action, which this would be a big one? This in essence would make an architect or an engineer an insurer of a multi-million-dollar project. It's a pretty, I mean, that's a lot. Why should we be doing that when the legislature didn't do it, and the legislature did do something else that created a pretty broad cause of action for anybody who has a building code violation? Sorry, I don't mean to keep cutting you off. Why should we as a court then just say, okay, well, we'll create a new cause of action for you here today, Mr. Rosenthal?
Not asking you to create a new cause of action. The cause of action is called negligence. It's been around forever. The issue is whether that you're getting at is whether the legislature sought to preempt a common law negligence claim. And I do not think anything in the statute says that. I think that section 5B, which your colleague pointed out, it says this: the fee owner of a threshold building shall select and pay all costs of employing a special inspector. Then it says, but the special inspector shall be responsible to the enforcement agency. What that's saying is a carve out from the prior clause of that sentence. The main clause of the sentence is the person who's got to pay it is the fee owner of the property for the service. But that doesn't take the responsibility of the special inspector away from answering to the government official, which makes sense because the government official is going to rely in issuing a certificate of occupancy upon the certification by that special inspector. So I don't think that language does nearly as much work as being talked about. I've got 30 seconds left. I'd hope to just address the following things. In trying on it,
You only have 30 seconds left because he reserved 4 minutes, but then he also had 5 minutes. So I think he's actually got a little extra time. He
That's
stopped
fine
4
with me.
minutes early. Yeah.
Thank you. I will try to be very brief, but to your point, Judge Smith, in trying on, I would urge the court to look at page 918 of the opinion, where the Supreme Court talks about the fact that there's not a common law cause of action, or there's never been recognized as a common law duty for a private person to enforce the law for the benefit of an individual. That was against a government agency, and that was a particular common law duty at issue. Here we're dealing with something entirely different. We're dealing with a garden variety negligence claim, common law duty based upon the facts of what this defendant did. Mr. Brown said, well, they're not responsible for the underlying conduct. Well, we agree, but their whole point is to see if the underlying conduct created a hidden defect, and they have to get into the building before it's closed up so that they can identify and flag a structural defect before it's hidden from view, before the building inspectors, the city rather, or county has to certify it for occupancy. So they have their own negligence, taking the complaint as true at this stage here, is particularly because this went out on duty, that they negligently failed to recognize some very fundamental structural flaws in these apartment buildings. That is creating a zone of risk to both the owner of that property, subsequent owners of that property, and residents in the building, anybody comes near it. So the zone of risk is established as a matter of their own conduct. So I would say the trial court simply misapplied McCain. It attempted to, but failed to do it in a fairly obvious way. And I would also just point out two other things in closing. Actually, one other thing, Judge Smith, you asked me whether there's any other engineering cases. The Luciani versus High case, which we cited at pages 38 to 39 of our initial brief from the 4th DCA, is an engineering company that's held liable to a subsequent purchaser. And to just close, this focus on the economic loss rule, I would add that was not the subject of summary judgment briefing. It was not raised as a basis. The only reason it kind of creeps into this case is that it animates some of those older cases that are pre-McCain, that are specific to the Supreme Court trying to create a limited form of liability in the sort of space relating to real property issues. What McCain did is it said, we're going to wipe the slate clean, and as subsequent Supreme Court decisions have made clear, that that's the intention of McCain. We're going to have a single inquiry about duty, and then we'll rely upon the other prongs of the negligence tort to winnow down and limit the aperture of liability. So there's nobody being made an insurer here. That's talking points. What the reality is that if there's a duty, we just proceed to the next phase of the case. We haven't taken discovery into proximate causation. That may be an obstacle in this case. And so therefore, we would say that the court cannot, I'll close, Judge Nardella, the court cannot affirm on proximate causation because that issue was not raised at summary judgment. That would be a due process violation, nor could it do so on the economic loss rule. And therefore, we would just urge the court to focus in on the sole limited issue in this appeal, whether or not the duty exists in this particular case. And we submit that it does exist, and we should live for another day to litigate the many issues that the court is wisely raising, but they should be raised at a later date. Thank you.
Counsel, thank you very much. It was well argued and it was well briefed, and we appreciate that. That said, we are adjourned. Have a good day.
Thank you.
Thank you.
Bye.